Right then, good afternoon, colleagues. I'm going to read the code of conduct that we now read at every NASUWT event. The NASUWT is committed to ensuring that all members, reps, staff, visitors, contractors and other third parties behave in a courteous manner at all times when engaged in work for and on behalf of the union. Aggressive, offensive, intimidatory or unacceptable behaviour will not be tolerated. The NASUWT has a zero tolerance for any type of harassment. This supports the commitment set out in the NASUWT rules to promote equality and inclusion for all and to eliminate all forms of harassment, including sexual harassment, prejudice and unfair discrimination. It is crucial that everyone can participate in NASUW activities in an inclusive, respectful and safe environment. Welcome to the second of the National Training Committee's autumn term caseworker webinars. We are delighted to welcome Paul Watkins, National Negotiating Official, who will deliver today's webinar on miscarriage leave. You may remember that we had a miscarriage leave motion carried at annual conference this year, and this webinar addresses some of the asks of this motion. This webinar will count towards your ongoing caseworker accreditation, and those viewing today will have their training records updated. Please use the chat for general comments and the Q&A for questions for Paul to address when he's finished the PowerPoint. Over to you, Paul.
Thank you very much, Kim. Good afternoon, everybody. Very nice to be here this afternoon doing this presentation. It will be a PowerPoint. Apologies for that. I know it can feel a little bit like death by PowerPoint, but obviously, as we all know, it is quite a convenient way of getting quite a bit of information across. And as Kim said, if you keep the chat for general chit chat, hello, where there's snow, giving us our updated weather reports, as it were, then obviously we'll take questions at the end. If you could put them in the question box, the Q&A at the bottom, then that'd be great. And if there are questions we can't answer today, then hopefully we'll capture them and we'll look to come back to colleagues with those as soon as we can. I'm not sure how we would do that, Kim. Will we just be able to send an email out to those who attended if there are questions with the answers on?
Yeah, well, I can take a copy of all the questions and then we can circulate the questions and the answers to attendees after this session if we don't manage to answer them today. So
yeah, brilliant.
Yeah,
thank you. I thought that'd be the way.
All bases.
I thought that would be the way. I just wanted to confirm in case I didn't get it correct. So I'm going to share my screen. So hopefully everybody can see that.
Yeah.
Brilliant. Thank you. Always good to get confirmation. So obviously, yes, I'm here to present about miscarriage leave, which, as Kim quite rightly pointed out, was balloted very highly and was therefore on the conference motions for last year's annual conference. And it was resolved that we would look to do something about this area. And I think that's quite right. It is an important area and it's important that the union seeks to address some of the issues in this area. To that extent, it was taken to the TUC as a motion and was also passed as a resolution of the TUC back in September last year. So obviously this is quite an important area for us and we're looking to do some work in this area, and obviously the training today forms part of the work that we're doing to just develop and enhance people's understanding, but also giving some advice and guidance on what to look for in terms of any policy moving forwards, if indeed your employer does already have a policy or doesn't. So when we talk about miscarriage, it sometimes comes under the banner of pregnancy loss. And we'll talk about that distinction between maternity and other miscarriage, sorry, not maternity, miscarriage and other types of loss, pregnancy loss in a minute, to just draw out the distinction between the different types. So in the UK, it is quite a high figure of pregnancies. In doing some research for this, I was quite disturbed by this. About 1 in 4 pregnancies end in loss during pregnancy or at the stage of birth. And as we know, pregnancy loss can happen under lots of different circumstances. But irrespective of the circumstances, it can, as we know, have a very big impact on both the personal and professional lives of those who've had the misfortune to experience such a loss. And I also think it's important, and I've been trying to drill this home to employers I deal with, that it's important to bear in mind that the loss is obviously significant for the individual, but it's also significant and can be significant for those around them in terms of maybe grandparents that are excited in anticipation of the birth of their grandchild or whatever, or it can be that their partners are also traumatized by the experience. And I think sometimes policies tend to focus on the individual, and that's quite right. I'm not saying that isn't the case, but also there is a need to focus on those around them and the trauma that they may suffer as a consequence of this horrible situation. And I also think it's important to recognise that when you look at somebody who's experienced the emotional loss and the trauma and the tragedy that goes with it, there isn't necessarily a one-size-fits-all approach. There isn't a response that all people who go through this experience. And I think, again, when you talk about developing that into policy and what it translates to on the pages of a policy, it is important for employers to make sure they do this and treat it very sympathetically on a case-by-case basis. So some people, when we talk about pregnancy loss, they may miscarry early on. Others may experience pregnancy loss further down the line. And that has an impact on their feelings about it and their attitude towards it and how they respond. For some individuals, it can be a complete and utter shock. For others who have maybe have been going, for example, through fertility treatments and have had, I'll get my words out properly, apologies, fertility problems for a while, there may be an expectation that this has been part of that process, and therefore they may feel they are better adjusted to deal with that. Others may be looking at a pregnancy termination for important health reasons. So this all adds to the fact that the experiences are different, they're varied, and it's important to factor that in when you're looking at a policy. Irrespective, though, one of the things that a lot of people talk about, and a lot of charities who do a lot of very excellent work in this area talk about, is that word bereavement, the sense of bereavement. So irrespective of how the pregnancy ends, or the ending of the pregnancy and how it comes about, the bereavement, the sense of loss, is often referred to. And obviously, this situation could be made far worse if there is a lack of support from the employer, a lack of understanding, empathy, sympathy, sensitivity towards this issue from the employer. So a lot of this webinar today is taking you through how to hopefully negotiate, work with employers to make sure the right sort of support is in place so that they are making sure those employees that have this horrible thing happen to them, and nobody will wish it on anybody, but if it happens, there is that support mechanism in place and they are dealing with it, discretion, sensitivity, and trying to support the colleague as best they can. When you talk about pregnancy loss, it is important probably to understand the different types. And one of the things I would suggest if you are looking at policy is a policy does identify the different types. So the reason why we talk generally at the start about pregnancy loss and then we're focusing more on miscarriage is because miscarriage is defined as the spontaneous loss of a pregnancy before 24 weeks. And that period of time before 24 weeks is fundamental to what we're going to talk about in more detail this afternoon. And obviously the conference motion, if you're aware of the conference motion, the TUC motion, because the 24 weeks has some legal importance and significance, and I'll highlight that in the next few slides. So in terms of a miscarriage, it can be broken down into an early miscarriage, which is seen as a miscarriage before 13 weeks, or alternatively a late miscarriage, which may happen in the second trimester, which is between 30 and 24 24 weeks. So then you've got obviously different types of miscarriage. So, and then you've got obviously stillbirth. So the key distinction is you've got miscarriage before 24 weeks. When it happens after 24 weeks, the technical term that is referred to is it's a stillbirth. Okay, so but there are other types of pregnancy loss. So you can have what's known as an ectopic pregnancy, where the pregnancy implants outside of the uterus, and that typically will, in that circumstance, unfortunately result in a termination for medical reasons because of the danger to those involved, because the pregnancy, the fetus hasn't developed inside the uterus. Other types include molar pregnancy, so which is extremely rare, but it does happen, a condition in which the abnormal tissue develops inside the uterus instead of an embryo. You've got recurrent miscarriage, where an individual may be unfortunate enough to experience 3 miscarriages in a row, which affects around 1 in every 100 couples. You've got IVF failure, so the failure where fertility treatment doesn't work, which could be a result of the failure to successfully implant. And then you obviously have circumstances where there may need to be an abortion or termination. So the artificial removal of expulsion of the embryo or fetus. So I did say I'd come on to the importance of 24 weeks. Now, the reason why 24 weeks is important is because it is it's the point at which medically research points to the fact that the fetus would have the potential to survive outside the womb. So before 24 weeks, lungs and other vital organs are not considered mature enough for life to sustain itself. So that is where we get into the legal background and context of what we're talking about, particularly around miscarriage. So if after 24 weeks, then there is a much higher chance of survival if the baby is born prematurely. And so it is seen as a different stage of pregnancy. So you've got this distinction between miscarriage, late or early miscarriage happening before 24 weeks. After 24 weeks, we tend to talk about stillbirth. But after 24 weeks, that's the point in which it's argued to be much more likely that the baby would survive if it needs to come out. And as such, it's seen as a different period. And it is important because, and we're going to talk about this in a minute, in terms of miscarriage particularly, but 24 weeks is reflected in the law. So essentially, if somebody has a stillbirth after 24 weeks, they lose their child after 24 weeks, they are in law entitled to receive the full maternity, paternity, parental leave and pay, including up to 52 weeks maternity leave, as well as an additional 2 weeks statutory parental bereavement leave. So they are legally entitled to have that time away. This is why we are interested, because if you suffer a miscarriage that's before 24 weeks, you get nothing. There is no legal entitlement to any statutory leave or pay. And that's regardless of whether the miscarriage happens 1 week into the pregnancy, or it could be 23 weeks and 6 days. So you can see there is this cutoff time supported by obviously research, but the unborn child doesn't know that, and the circumstances don't know that. So it does seem like it's slightly unfair that it could be 23 weeks and 6 days as opposed to 24 weeks, and one receives the full entitlement and one receives nothing. And that, as a union, is a situation we don't think is acceptable. Neither do other sister trade unions in the TUC. And so we argue, we think, and I think this is entirely right, that every teacher, irrespective of whether it's pre or post 24 weeks, who experiences pregnancy loss should be given the time and the space they need to deal with their loss and to recover and recuperate. And this is quite an important part of the sort of campaigning work we'll take forward. We want a change in the law to reflect this because we don't think it's acceptable. And as you can understand, this formed the basis of a motion which we referenced at the beginning, which was passed at conference this year. So conference is concerned that members experience a miscarriage before the end of the 24th week of pregnancy are not entitled to statutory maternity, paternity, or parental leave or pay. So any time off would be at the discretion of the employer. And we know what that sometimes means. Discretion means grace and favour. If you're received positively by your employer, if you just get on and don't ask any questions and you aren't considered to be awkward, you might get some leave and the head may give you that with pay. If you're not, then the head may treat you very differently. So we know, I've never been a fan of the word discretion personally, because it does throw itself open to grace in favour, doffing your cap and hoping that when you ask for something, it falls on favourable ears and they're listening. So as a consequence, conference calls on the National Executive to campaign for a change in the law with regard to miscarriage and have it included within maternity and paternity rights, right to all employers, urging them to remove miscarriage from a sickness absence policy and treat it as an independent condition deserving its own policy, inform and educate all reps on how to tackle miscarriage and sickness absence with employers, and then finally work across the TUC and affiliated unions to develop a model policy and training for reps, seek to ensure that supply teachers are covered by the model policy. So, as we said, the union believes every teacher who experiences pregnancy loss should be given the time and the space they need to deal with their loss and bereavement and recover and recuperate, recognizing that no two situations are the same and an individual's experience of a pregnancy loss may be very different to another individual in the same school or setting. So there does need to be that drive to treat this on a case-by-case basis. So there is a need for support in the workplace. Often, employers fail to understand the impact and implications on those directly involved, as we said earlier on, including family members and partners and close relatives. So it is crucial that schools, colleges have a policy in place that provides the right structures and support for those that are impacted and fundamentally treats those who experience this with sympathy, dignity, and respect. This isn't like any other off-the-shelf policy. This is a time when people are genuine at an extremely low end. And so the same process and the same application of this policy, to any other policies, it's got to be moderated. It's got to be different. It's got to recognise the situation. And that feeds into discussing later on, the role of managers, senior leaders, and the school in general, and the school workforce. So according to a survey carried out by Tommy's, which is a charity that deals with a number of these issues, 1 in 5 people who've experienced pregnancy loss received no support from their employers. And only 40% felt that their manager showed an understanding of the associated challenges. And a 2022 report by the Chartered Institute of Personnel and Development, or the CIPD, found that only 25% of employees receive paid parental bereavement leave following baby loss, and just 37% have formal pregnancy loss policies in place. So there's some context in background that demonstrates there is work to be done. So it's just a very quick question. I don't know if you, in your setting, where you work, does your employer have a policy in place? Now, another question for you, was it consulted upon? And if there is a policy, do you know what support it offers? Now, I don't know if colleagues want to just put stuff in the chat. Maybe I should have asked this as a opinion poll, a short poll. I don't know what you think, colleagues. Do you know if your employers have policies in place or local authorities?
We've got people saying no, Paul.
Okay, right, no. Yeah, quite worrying that, isn't it? I mean, the one thing, in a slight defense of some employers, is that, you know, quite a number of the employers I deal with are sympathetic to this. And it might be the case. So it might be worth going back, bit of homework as it were, to look at whether it's captured in other policies. Because having dealt with the employers I deal with, a lot of them will say when you talk to them about this, they're receptive, they want to listen, but they will then say, well, we've got it captured in a special leave policy. We have a compassionate leave policy. Some will say they've got miscarriage captured in a general pregnancy loss policy. So there are employers out there that recognise this and have made efforts to ensure that there is provision to protect and support employees of theirs, their teachers, when they have the tragedy and misfortune to experience this. And again, I did say if you knew of a policy, and by the sounds of what Kim was saying there, the vast majority are saying no. So you can go back, you can start making the point after this, using the slides to make the case for a change and make the case for a need to have a bespoke miscarriage leave policy in place. Then obviously, you know, what support does it offer? My experience has been that the support varies. Thankfully, most employees I've had the experience to deal with do offer some level of paid support, but it does vary between 5 to 10 days. And often it's captured as a different, it's not bespoke. So one trust I went to the other day, we talked about this, and to be fair to them, they've got some provision for this, but they actually give it a generic term of personal days. An individual can have up to 10 paid personal days. And I did try to make the point that I think, given the status and the situation, you should maybe look at having a bespoke miscarriage leave policy, even if it was a pregnancy loss policy, and within that captured miscarriage. I think that's the way, and certainly given our motion, that's the direction the union wants to take. And we are encouraging employers to give consideration to that. And if they've got something in place, to then reconsider and rethink what they've got to maybe sit more aligned with what we as a union would expect. So there's a bit of homework to do by sounds of it from what some of you said, in terms of no, you don't think there are policies in place. So obviously the slides will help you to go to those employers and start saying, we'd like to talk about this, here's what we want to talk about, and here's how it should look. So when you are consulting or negotiating on a policy, then obviously as a union, our view is that it should apply to all employees. So there shouldn't be any sort of eligibility criteria. We know that is quite common in policies. A lot of the law has qualifying periods for certain provisions. So for example, prior to April this year, you used to have worked with an employer for 6 months before you can make a flexible working request. And that's no longer the case. It's now a day one right from day one of employment. So we would like employers to make sure that this does apply to all their employees from day one. And obviously, as you can see from the conference motion, slightly maybe more tricky, but we would like to see supply teachers captured by that. Now, that could be a supply teacher who's directly employed by the school, so they come in and do supply with an arrangement between them and the school, or it could be if we're really going for it and really looking for a progressive policy with employers, why would it not cover an agency worker? If an agency worker suffers the trauma and loss, why are they different to other employees? Only because one's more permanent and one's more temporary. But the loss, etc., is still the same. So really progressive employers will want to make sure they treat all staff in the same way. And we would advocate that that would be something we would like to see in policies. The policy should define miscarriage. And again, we've talked about that and the various forms it should take. So it understands, it shows an understanding of the research in this area, the fact that it's not a one size fits all. Not all miscarriages are the same. Not all miscarriages come about in the same way. And therefore, yeah, that there should be an understanding of that. And defining it and the various forms it takes is an attempt to do that, and will tick that box. Any policy should also front and center to me in the policy. If you're talking about a scope or you may want to call it a statement of intent in a policy, it should say that they recognize and acknowledge the importance of creating a safe and supportive environment for those, for treating expecting mothers and their partners with dignity and respect at this time and at all times in this process. And also front and center should be the fact that they will treat miscarriage on a case-by-case basis, recognizing the varying impacts on those affected. And if you wanted to add into this, you would want to maybe get them to use words like, acknowledges the importance of creating a safe and supportive environment and treating expecting mothers and their partners with dignity, respect at all times, using words like sympathy, discretion, sensitivity, providing a supportive environment. So those words are important because essentially, if an employer is going to, talk the talk and walk the walk, it's got to be front and center in the policy. It's got to be there. It's got to say, if it's going to do that, it should say what it does on the tin. Yeah, because far too often you will see employers say, "Oh, in practice," and then you have to say, "But the policy is this." It doesn't matter what you say in practice you do, because if you all leave tomorrow, what would somebody pick up as a policy on this, and what does it say? So to me, it's important. If you're going to put your money where your mouth is, then put it, badge it. It should be on the tin. Yeah, I think that's really, really important. And thankfully, I think employers do and are receptive to that message. Any policy should have quite clearly an equality statement. It would seem very odd to not have an equality statement based on the fact that issues around maternity, pregnancy are protected characteristics under the Equality Act. It should make it clear that the policy operates in accordance with the duties to promote equality, to eliminate discrimination, and to promote good relations between staff with protected characteristics as required under the Equality Act 2010. It might also want to make reference to its public sector equality duty. So there is that additional point to make. And also the policy should confirm it's been negotiated in consultation with recognised trade unions, including the NASUWT. You may want to seek to get also an inclusivity statement in the policy, because I think we need to recognise that miscarriage can affect people of all genders and sexualities, including non-binary individuals and those in same-sex couples. So it might be worth pursuing as well an inclusivity sort of statement within the general equalities angle of the policy. So we come on to the leave entitlements. Now you will note here, I've used the word minimum. I expect this is a minimum. I would expect a minimum of 10 working days paid leave. I would also expect a minimum of 5 working days paid leave for parents and close family members. Because it may be that the partner is the person who works in the school and their partner works somewhere else and is the one that suffered the tragic loss as an individual. So maybe that you are. So I think sometimes when you talk to employers, they tend to focus on what if it's a member of staff who suffers a miscarriage. And you've got to elaborate them and say, well, what if it's not the individual's not a member of your staff, however, their partner is a member of your staff, or the father of the person that suffered the tragic loss is a member of your staff. And again, I like to be fair to people where I can. A lot of employees, when you start teasing this out with them, the penny drops. They go, that's a really good point. I hadn't considered that. So there is an opportunity to push it an open door there. And we also advocate 5 days paid leave for intended parents of surrogacy as well. And it should include the provision for more time to be taken, follow the recommendation of maybe occupational health through an occupational health referral or a medical practitioner. So I think it's important we say it's a minimum. And I know some other unions have gone very bold and said it's a month. I don't disagree with them. So that's why I've said it's a minimum. We would expect it to say a minimum of 10 working days paid leave. Now, why we've got the bottom bullet point there, and I notice the conference motion, and you could quite legitimately throw back at me, this is sort of conflicting with that motion. But if a person needs more time off, and I probably would hazard a guess, and I'm fortunate enough to have never experienced any of this myself, I know colleagues and friends who have, I would hazard a guess that a lot of people may need more than 10 days, or 14 days if you talk about in terms of 2 weeks without the working days, then I think what we might be looking to do is basically talk to them as a union representative dealing with a case, or get the school to talk to them about maybe managing this then through a sickness absence mechanism. And the reason I say that is because if they go to a medical practitioner or through an occupational health referral, they say they're still suffering either the psychological damage or there are still physical issues to be remedied, then if they're signed off and it's under the sickness absence policy, that is protected by law. So the member can't be challenged as to why they're on that leave. So this is why I think you have the policy says it's 10 working days, and then if they need more, the policy should say they should seek a referral, they should go see their GP or a medical specialist or practitioner in this area, or through an occupational health referral. And then if they recommend they're off longer, they cannot be, as it were, touched, because they have that backing in law that it's protected under pregnancy-related leave rules. So it's covered under the Equality Act. It's pregnancy-related leave. So the employer has to therefore record it separately to any general sickness absence leave, and it cannot be used against the employer for any attendance management issues. So, for example, any promotion decisions, any pay awards. It cannot be used for any factors in terms of redundancy. It cannot be used for any disciplinary issues. It's a specific category protected in law. But that would only come about, in terms of probably through a sickness absence route and getting a medical professional to identify they need that time off. And that time off under the Burgundy Book, if your employers adopt the Burgundy Book provisions, could be up to 100 days paid full pay. So the reason why I say that is because obviously if we are looking at a minimum of 10 days and that's exhausted, we shouldn't be pushing the member back, or the employer shouldn't be focused on when are you coming back. The option should always be to draw upon and access further enhancements and further opportunities for leave, because they need to be in the right place. That's the most important thing. This individual being in the right place, in the right frame of mind, in the right place for them to return to work. Okay. So it's really important, I think, to just be aware of that in the round in terms of the policy. And I think I think it strikes me as extremely odd that if you have a miscarriage before 24 weeks, you don't get any leave or entitlement like somebody post 24 weeks does. However, if you're absent, it is covered by the law. It just, so again, you can see the campaigning around this. It strikes me as they just haven't, dotted all the I's and crossed all the T's in regard to this. Haven't thought it through in terms of it is protected here, but in terms of the payments aspect and the leave aspect, it isn't legally protected there. It, to me, doesn't make an awful lot of sense. Furthermore, when looking at a policy, then we are looking at a section on confidentiality and privacy. That's fundamental given what we're talking about. There should be a quite obvious statement that all discussions will be treated with the utmost confidentiality and sensitivity. And I think it's important, any communication to other members of staff, or if so be it, to any students or pupils, then there should be, that should be done with the individual's permission. And if the individual's not comfortable, then obviously there may be a discussion that has to take place with the individual about what is going to be communicated. But that all should be agreed with that individual's explicit consent. Yeah. And I think it's important to say the individual's explicit consent, to emphasize the point that at no point would an employer put something out there or discuss something with others that the individual's not aware of. And that obviously might take place at an appropriate time. So it might be the case the individual is just off and they're absent. And at an appropriate time during that period of absence they're off, they may decide, and again, it's their decision, and this is where the trade union role would come in, to assist and support them and support and assist the interaction with the employer, to act as the conduit between the two. They decide when it's ready for them to communicate it. So it may not be straight away, it may be over a period of time. Counselling and support. So it should reference that there is free, professional, confidential counselling services. A lot of employers will have an employee assistance programme or EAP that's available. And again, it should reference the role of occupational health in terms of extending the leave, but also in terms of saying this person needs some referral to some support mechanism. And occupational health are good at doing that, good at assessing. That is their skill, that's their expertise, that's the role they hold, at assessing the situation and allocating or recommending a resource to do that. It may be the case that the individual has to go to some sort of follow-up appointments to be medically checked out, to make sure any processes that are involved is horrible as they may seem, but any processes that have to be involved, are going, are working according to how they should. And so obviously the policy should commit to paid time off for the individual to attend medical appointments related to the pregnancy loss. So follow-up care counselling sessions as it may be to deal with their bereavement. Now, there is also an argument, and apologies because it struck me that I haven't included this, but there is also an argument maybe their partner would want to support them. So there is an argument maybe there should be provision in a policy to allow partners, just like you have for, say, antenatal clinics in classes, partners can have access to, I think it's 6.5 hours with paid leave. So obviously you might want to allow the partner, or if the individual doesn't have a partner, a close family member, to have some level of paid time off to support the individual if that's appropriate. A policy should also confirm flexible scheduling. So, the person will be allowed to be off for that reason. There's flexibility around how they operate in a school scenario in terms of being in, not being in, etc. And I think also as well, there is an argument with this, that employers shouldn't be chasing them for, well, have you got work that we can use to cover your lessons. I think there should be a discussion a head of the department has with any school leadership that is aware of the situation in confidence. It may be that it's not disclosed why they're off. They are just off. It's a personal reason, but obviously, could you, as a head department, could you ensure there is adequate work and appropriate work left? And I think so. So when we talk about communications, etc., I think that's a fundamental part as well of communication. And then when the individual is ready to return to work, then obviously we would expect there to be some level of phased return to work as agreed with the individual. So we would expect there to be a meeting held to ask how the individual is, to assess them, to assess whether they're ready to return. And if they are ready to return, well, obviously, would they like to return, as they were before in their full-time role, or would they like to have some level of flexible arrangement, which might include, as we know, in the world of COVID, Zoom, Teams, etc., or remote working options, or just a plain phased return to work, which effectively means, for week 1, I'm coming in 2 days out of the 5. For week 2, I'll come in 2.5, etc. It will gradually, incrementally increase over time. And wellbeing support, when we talk about phased return to work, obviously managers will liaise and work with the employee to assess their needs. So if they are agreeing a phased return and after a few days the individual says, I don't think I'm quite right yet, I don't think this is the right place for me to be at the moment, okay, my mind is not on, then obviously there's the ability to, as well as ratchet up the amount of time they're in school, to go back and draw down the time they're in school. And that should be done again in a sensitive and discreet manner. Now, obviously, we will expect, as you would, because we are a trade union, we would expect there to be front and centre in the policy a reference to the important and vital role that trade unions play. As I said, acting maybe between the conduit, as a conduit between the individual and the school, if the individual isn't ready to speak to the school, maybe working with the school, but obviously fundamentally front and centre, working with the individual and assisting and supporting them with their loss. So we would expect them to have the right to be accompanied and supported at all meetings and with any other associated issues. It's also important to recognise that there should be training and support for managers. Managers may never have dealt with this, and touch wood, a number may never have to. But when it does occur, is it appropriate for a manager who hasn't got the skills and expertise to be dealing with this? No. So there should be a commitment to make sure they are trained to understand. So there is guidance provided to them. There's lots of guidance out there. The Miscarriage Association probably being one of the key bits of guidance to use. It talks to how managers should speak about it, the language they should use. And that goes for trade union reps as well when dealing with this. So, they should have that training. They should feel confident that should this tragic situation ever arise, they can be professional, they can be supportive, they can approach it with sensitivity. As I said earlier on, this isn't like what other policies are involved in. This is something very different, unique. And so they should treat that situation in that way. And obviously it should include signposting for support for managers, to help them understand what's going on. So this could be the Education Support Partnership or a range of other different organisations, because for the managers as well as individual, it could be distressing for them to listen to it and to deal with it. So for all concerned, there is an obligation to support the welfare of all parties involved. So I think that is an important thing to ensure a policy commits to. And obviously, policy would be really helpful if it signposts to further support. So you have a range of different organisations here. There are more. So you've got the Miscarriage Association, good starting point, because they do actually, if I'm right, they've got examples of model policies for certain employers. I'm not, by the way, saying they are model in terms of what we would define as model policies, but they've got some examples. They've got some examples of what employers say and what employers do. They've got examples of the sort of conversations that management should have. So again, that can inform you taking this forward on behalf of the union. You've got Petals, Tommy's. Petals provides specialist support and counselling after pregnancy loss. So that might be something for a signpost for a school business leader or manager. Tommy's is a charity that funds research into pregnancy problems and provides information for parents to be. SANS offers support if your baby dies during pregnancy or after birth. ARC is a national charity offering support through antenatal screening and its consequences, which could include bereavement. You've got Abortion Talk there, which offers non-judgmental and supportive environment. Fertility Network, you've got the Ectopic Pregnancy Trust, which clearly is very niche and specialist, dealing with early pregnancy complications. So a range of other places to go for further advice and guidance and support, and a policy should recognise that and signpost that to assist managers in maybe broadening out their understanding to be able to deal with these things effectively. Excuse me. We would obviously expect as well a policy to confirm that it will be monitored and reviewed. So that would include confirming any individual records are treated as confidential. That means they're only shared with those that need to know about it, as in when, and obviously in regard to this, probably with the explicit consent of the individual concerned. It should confirm that policy be monitored to ensure its consistency of application and adherence to the relevant equalities legislation, as well as confirming that it be annually reviewed and monitored. And it could be the case that there is there's a date. Some policies will say, "Oh, we'll review it every 2 years." Some may say every 3. Some may say every 5, depending on how important they are to be reviewed. And when we talk about this and policies being reviewed, it should be the case that policy isn't just reviewed because it suits the needs of the employer. If we as a trade union have important things that we want the policy to include, it was within our right to also say we would like to review the policy. I know it's not 3 years yet, but we've got something we want to say on it. We've got something to offer, because can we review it? Otherwise, it gets into a position where you don't ever talk about it and you don't get the chance to then review it, because the employer wants to stick to a rigid schedule of when it does things. So I think that is me done. So thank you for your patience. And obviously, I'm happy to take any questions and answer as best I can. So obviously, we've got Nicole, if I've said that right, apologies if I haven't. Fife Council, 2 weeks full pay. Yeah, that is the starting point. I think that is, as far as we're concerned, our minimum expectations. That's really good. Maybe the next time it's subject to review, see if you can ensure there is some movement on that. It potentially could be the case that you secure movement in terms of that discussion we had about, if a person feels they need more time, then obviously direct them maybe to occupational health medical professional with a view that they will be able to access additional time within the sickness absence leave policy, given those protections we discussed. I think those protections are fundamental, which I'm happy to be shot down on. This does maybe potentially sit at odds with the conference motion, but I think I think if I'm being pragmatic, it's sort of like it does resonate with the motion because it provides a separate type of leave with the provision that you can also take more. And there's those protections in law, which I think are fundamental in accessing that leave. So as far as I can see, Kim, they are the only two questions, but I'm happy to open it up if colleagues have
We've got
questions.
one in the chat. Jeanette has asked, does this apply to missed miscarriages too?
Oh, okay. Jeanette, can you just clarify what that means? Do you mean if somebody's not aware they've had a miscarriage?
While we're waiting for Jeanette to reply, I've just put in the date of the next webinar and the link if you want to sign up for that. It's on Friday, the 13th of December. And then there was a couple of other comments as well. Tim said that after 24 weeks, discretionary under special leave, otherwise, I'm not sure about that, but he's raised it with corporate HR and will continue to raise it.
Yeah, good on you. Good on you there, Tim. I mean, I do think my experience has been, when you talk about this, because of the nature of the workforce and education, predominantly being female, I do think you are pushing a door that is at least slightly ajar. I think a lot of employers, and you know, we can wax lyrical as you, can't we, about recruitment and retention. Other employers are doing things in this area, you know. So I think, you know, if they want to retain their workforce, then obviously this is something, as tragic as it is, this is something that will, you know, give them that edge, dare I say it, in terms of the range of protections they offer to our members.
So Jeanette's, I think it was Jeanette, wasn't it, has come back in chat. Yes, and that body thinks you are pregnant and that you get positive pregnancy tests, but then the baby hasn't developed.
Yeah, I have absolutely no reason to think that would not be captured in terms of, you know, the broad definition of miscarriage. Obviously, the individual, you know, may want to go to seek help and assistance and advice for a medical practitioner, but I think that would be the key thing there. Janet would be going, getting that advice, getting the diagnosis from a medical practitioner, and then utilising this policy to ensure that person has time off. Because I mean, to me, that sounds certainly like there'd be quite a lot of physiological issues that may go on, and that I wouldn't have thought. I'm not a female, so apologies. I haven't lived that experience. I'm sorry, but I would just try to be sympathetic and understand that that person probably wouldn't be in the right space to be in front of a classroom. So for me, I think it should be captured. So it's a really good point, Jeanette. I'm going to write it down because I'm going to make sure we add that to our list. So thank you for
that. I'll just let you do that.
It's always good to learn something. Every day is a learning day.
And then the last comment was from Kevin, who said, our policy is only after 24 weeks, nothing for miscarriage before the 24 weeks, but it does says 10 days with pay. So I suppose you talked about that as being the minimum, didn't you?
I would like to see it as the minimum. I've been quite harsh with some employers when they've sort of said that and said, oh, it's really wonderful. I've sort of said, well, come on. Do you think after 10 days people are in the right space and place? So come on, it should be the minimum. But the danger is then, I think it's a good point, you use the word discretion in what you're reading out there, Kim. The danger does become, it's that discretion. Oh, you can have 10 days, but we may or may not give you any more. So I don't like discretion, because discretion means if I like the individual, they can have some more paid leave. If I don't like them, no, they're not getting it. Well, they're both suffering the same trauma. Why would anybody, whether you like them or not, it's irrelevant. They're both gone through a very traumatic experience. Just give them the leave, you know. I mean, and the problem becomes as well, if you use discretion, then often they use words like, oh, with the option to have discretion for another 5 days unpaid leave. So I'm tempering my point slightly by saying, if it said discretion for another 5 days paid leave, then I think most employers, if they are, if they are in the right, if they are sympathetic and they are sensitive and they are show compassion, then they would straight away say, yeah, just take the additional 5 days. But obviously, the trade-off is, well, if the discretion is, well, yeah, maybe, maybe not, and it's not with pay, then I would, if I was a caseworker, I used to be many years ago wearing a different hat, I'd be pointing them to the sickness absence leave policy and saying, well, that's the route I would suggest we look at, because it comes with all those protections, doesn't it? In terms of the amount of leave you can have. Your GP says you need 2 months off. You've got 2 months. There will be no problems because you won't be touched because of the nature of the leave being covered by those pregnancy-related protections under the Equality Act. So, to me, and I'm happy to be shot down, it does sort of sit at odds with the motion, but it complements the motion, maybe is the better way of saying it. Here's the
Yes.
leave in the policy. Here's also leave you can access to make sure our members are protected. And ultimately, I see that as what we're supposed to do, is protect our members to the best of our ability. So
yes.
hopefully that was helpful.
No, that's really good. And I think the discretionary is a bit like inequality law, reasonable. My reasonable might not be your reasonable. And that always is a bit of a bugbear for me as well.
And you're right, Kim, because when you start going down those routes, and I've had the, is it a good, I've had the opportunity to discuss lots of things with barristers and lawyers in my time. I don't know if that's a good thing or a bad thing. It's always a bad thing when they bill you, that's for sure. I do think, they're always very keen to say, oh, well, the test of reasonableness, will it be established? But where will it be established? In an employment tribunal? The person's got to be dragged through all of that with their trauma.
Months and months of
So,
worry.
yeah. So, and also the delays in the employment tribunal system, as we know, are significant. So, would a person who's having to deal with the trauma then be fit to want to have to write it all down, lodge early conciliation, talk about it? I think employers, it suits employers as much as it suits the employees to have a system that allows us to recognise and acknowledge it, to provide the compassion, sensitivity, and support, and then hopefully the person to be in the right space for them to move on with that employer working together. That's where I sit.
Yeah, no, I would agree with you, Paul. There's a couple more comments that have come in. So does the employee need any evidence from a doctor that this has happened? This is the previous query. I don't think, well, you can answer, Paul, but I don't think there's any harm in being backed up by a GP or anybody, any other medical professional.
I suppose it's one of these things, isn't it? And I'm trying to look at how this works and mirrors across to other provisions around the topic of pregnancy. I think, when you're pregnant, you get your MAP-B certificate, and employers can request that as evidence for proof you're pregnant, etc. So I would say, and I appreciate there are issues with getting GP appointments, etc. I know that, but I would certainly say that having that in your pocket as the piece of evidence you need is fundamental. It sort of like dismisses any arguments or awkwardness or challenges you'd face based on the experience that individual's got. So I'd always recommend that they do that. Yeah.
And then the last one is back to Kevin again. Just looked, and it says a maximum of 10 days after 24 weeks, not a minimum. After 24 weeks. That's interesting.
Yeah. Well, I think, Kevin, you've had the presentation this afternoon, apologies. I think it's important to go to them and say, look, this is a flaw in the law. And I don't think most employers I've dealt with have actually already recognised this and not their policies. So I think, Kevin, maybe your local authority or your specific employer are slightly going to sit behind the curve on this, because a lot of employers who want to be progressive have recognised this, have seen it as a false distinction. It is a false distinction. 26 weeks, it's 24 weeks, sorry, or 23 weeks and 6 days. It just doesn't make sense that one person gets it, one person doesn't. It's a false distinction. I think that argument needs to go to them, and you need to present it. And I think hopefully they'd be open and receptive to listening to that, because I don't think, maximum 10 days. I'd like to see if you could sneak in the word minimum instead of maximum. giving them scope, isn't it? It's giving the employer scope to say the individual might say, do you know what? My disposition, the way I'm made up, I'm okay going back after 10 days or 7 days. I don't know, because I don't know the individual, the circumstance. But having a maximum of 10 days, imagine if the person's getting towards the 9th day and they don't feel right. They're now under pressure because it's a maximum of 10 days. So that's the Friday's the last of the 10 days. They've got the weekend, the Monday comes, all weekend they're worrying about this, the psychological trauma, the concerns about seeing their class for the first time for 2 weeks, and they haven't got the ability to fall back on more. And so that's maybe a conversation I'd be wanting to have with them, Kevin, if that helps. Jenny, I think in terms of early pregnancy, I think these things should be captured. Which is why I did use the word miscarriage and then provided some explanations of different types. But I'd probably, if I had to use the word, that list is illustrative, not exhaustive. And there may be other types, as medical knowledge evolves, there may be other types that somebody suddenly is established, makes it not this type of miscarriage, but another type. So I don't see why it shouldn't be in there. That's a really good point.
Right, I think that's it then, Paul. Well, thank you very much. That was a very comprehensive webinar, and we will share the PowerPoint with everybody who's logged on today. With your permission, Paul, I think I'd also like to put it in the caseworker section of the website.
Yep, I'm happy with
that. So only our caseworkers will be able to access it. I think that will be good. And then when the recordings come out properly, people will be able to access the PowerPoint as well. So that's absolutely fabulous. Right. Thank you very much for attending today and giving up part of your Friday afternoon. When it finally comes, I hope you have a lovely weekend. Thanks once again, and all the best.
Yeah, thanks, colleagues. Have a good weekend.